Welcome, welcome, welcome. How y'all doing today? Shirley here with another video. So, welcome to my channel, Just Being Shirley, right here on YouTube. So I have two channels here on YouTube. So both channels will be geared toward business or business related content. No gossiping, just business related. I want to talk about everything that pertains to business, marketing, advertising, promoting, trademarks, copyrights, patents, international marketing, global marketing. I want to get into a little law. I have some law terms that I want to present on my channel. And also I have a few books that I received from Strayer University when I studied at Strayer University. From the humanistic tradition, a lot of different people I want to bring forward on my channel. Charles Darwin, Plato, Socrates, John Locke, John Quincy Adams, Thomas Jefferson, Picasso, famous painter. So many different ones. So just want to talk a little bit about branding and marketing. Just a couple pointers. So in other words, when you brand, you want to have your logo. You have your logo on your products. So that will distinguish your brand from the next company's brand. So in other words, I have my logo. I have my logo on my label. So that is part of my brand. So that's how I brand. And this sets me aside from another company's brand. So when you're dealing with branding, you want to have your own unique logo. You want to have your unique logo. You don't want to use nobody else's logo because you can get sued. You can get sued for using somebody else's logo. So you want to, you can do a quick Google search and find a logo that's, best suited for your company, for your brand. In other words, you have your label, but you have your logo. You have your logo in your label, so that is called branding. This is how I brand, and this separates my brand from the next company's brand. So in other words, this is a hair growth product. Good too, so good. This is a hair growth product. So I was marketing previously hair growth products for men, women, and children. So this is part of my branding and my logo, so that it distinguishes me from another company's brand. I don't want to go steal nobody else's idea or nobody else's logo, because that would be part of a trademark infringement. So this is branding. Then marketing is your next step. How are you going to get your products out to your customer? You might have a service, or you might have a product. But if you have a service, then you have a service mark. So your service mark will distinguish your company's brand from the next company's brand. So you want to make sure you have a different service mark. But you can't reach for somebody else's service mark or trademark, for your product or your service, because that's trademark infringement. So then marketing comes in when you have a strategy or a plan to, get your products out to the customer. In other words, what marketing channels are you going to use? So marketing is basically getting the products out to the customer. Facebook ads, Twitter, YouTube, Instagram videos. You have text message marketing. There's so many different ways that you can, use to get your products out to the customer. You can have door-to-door marketing, whatever suits your company. So basically, marketing is getting the products and services out to the customer. In other words, if you have a service that you're offering, you might have a billboard. You might have a billboard advertising of your business. Even if I could have a billboard advertising of my business too if I wanted to, but it depends on the company. It depends on your company and what type of marketing channels you want to use. So I just want to also, and another thing, when you're dealing in business, when you're running a business or you offering a product, or offering a product or service, running a business or whatever, whichever one you are doing, you still need to know a little bit about the law. So I just want to read a little bit about contracts. Now this book right here is from Strayer University. But this book is from Strayer University and it's called Business Law. And so just a little bit about contracts. So a contract is an agreement based on mutual promises between two or more competent parties to do or refrain from doing some particular thing that is neither illegal nor impossible. The agreement results in an obligation or duty that can be enforced in a court of law. So in other words, a contract is an agreement and it's based on mutual promises between two or more competent parties. So in other words, you go into a contract with somebody, it could be two or more people, and it can be a contract where you can refrain from doing something, or you can do something. You'll be allowed to do something according to this contract. So it says it's an agreement based on mutual promises between two or more competent parties to do or refrain from doing something. In other words, you say for instance, you have a contract with somebody or with the court and saying that, you can't smoke. You ain't smoke those cigarettes, so you have to refrain from smoking those cigarettes because you have a contract. Now, you can breach that contract if you don't abide by the elements of that particular contract. All 6 elements of a contract have to be honored for it to be a legally binding, fully enforceable contract. So, in other words, elements of a contract. A legally complete contract will arise between two parties when all 6 elements of a contract are present: offer, acceptance, mutual assent, capacity, consideration, and legality. If any one of the 6 elements is missing, the transaction is not a legally complete contract. We have offer. An offer is a proposal made by one party to another indicating a willingness to enter into a contract. You have acceptance. In most cases, only the specifically identified offeree has the right to accept an offer. And then we have mutual assent. If a valid offer has been made by the offerer and a valid acceptance has been made by the offeree, then the parties have agreed to the terms, and mutual assent exists between them. Then you have capacity, the fourth. The fourth element necessary to make a contract complete is capacity. Capacity is the legal ability to enter into a contractual relationship. Then we have consideration. The fifth element to any complete contract is the mutual exchange of benefits and sacrifices. This exchange is called consideration. Consideration is the thing of value. Thing of value promised to one party in exchange for something else of value promised by the other party. Then we have legality. The final element of a binding contract is legality. Parties cannot be allowed to enforce a contract that involves doing something that is illegal. Some illegal contracts involve agreements to commit a crime or to perform a tort. Other activities that are neither crimes nor torts have been made illegal by specific statutes. So in other words, you've been asked to sign a contract. You've been asked to sign a contract. All 6 elements have to be available. All 6 elements have to be present for the contract to be a fully enforceable, legally binding contract. In other words, I ask somebody, hey, paint my whole house, I'll give you $5,000. So I'm offering them and I'm asking them paint my house, I'll give you I'll pay you $5,000. So the offer is paint my house. That's the offer. Then the acceptance. So if they say, yeah, I'll paint your house, that's the acceptance. Then the third thing, consideration. I say $5,000. I give you $5,000 to paint my house. So $5,000 would be the consideration. So we have the offer, we have the acceptance, we have the consideration, and then we have legality. So we have the legality. So it has to be a legally binding contract. Now, there can't be no contract that is based on sale of drugs or something illegal. And then you have capacity. So capacity, all parties to the contract have to be of age. So then we have the last one, mutual assent. That means both parties, all parties have to agree. So those are all the elements to the contract. Contracts and other agreements. All contracts are agreements, but not all agreements are contracts. That's true. In other words, all contracts are agreements, but not all agreements are contracts. So in other words, somebody can say, hey, wash my car, I'll give you $20. That can be just an agreement, not a contract. So I can understand that. So we have a valid contract, a void contract, a voidable contract, unenforceable contract. So a valid contract is one that is legally binding and fully enforceable, as I said previously, by the court. That's a valid contract. In contrast, a void contract is one that has no legal effect whatsoever. Then we have a voidable contract is one that may be voided or canceled by one of the parties. And then we have an unenforceable contract is one that, because of some rule of law, cannot be upheld by a court of law. Cannot be upheld by a court of law. An unenforceable contract may have all the elements of a complete contract and still be unenforceable. And then we have a unilateral contract. We have a breach of contract. A breach of contract occurs when one of the two parties fails to keep the promise. When there is a breach of contract, the injured party has a right to ask a court of law to remedy the situation. And then we have the express and implied contracts. A contract can be either express or implied. An express contract requires some sort of written or spoken expression that indicates the desire of the parties to enter the contractual relationship. An implied contract is created by the actions or gestures of the parties involved in the transaction. So, see what other terms we have. Try to get the most important. Okay, so when you're talking about offer and acceptance, it says the first element of a valid contract is the existence of an offer. It's explained in chapter 6. An offer is a proposal made by one party to another indicating a willingness to enter into a contract. So in other words, like I said, you ask somebody, I asked somebody to paint my house, and I offered you to paint my house, and I said I will give you $5,000 would be the consideration. But offer would be, hey, paint my house, that's an offer, and if they accept it, they will, there's mutual assent, they both agreed. Consideration would be number 3. Number 3 would be in other words, consideration is something of value. It's something of value. So, let me see what other term. So, basically they have it, different chapters. They have a chapter for offer, a chapter for acceptance, a chapter for mutual assent, consideration, capacity, and legality. So, they separated them in the chapters. So, a whole lot of good terms in this book. So, okay, I want to talk about negligence, elements to negligence. as I find it. This is so negligence, that's part of tort law. So negligence is part of tort law. Okay, let's talk a little bit about tort law. A tort is a private wrong that injures another person's physical well-being, property, or reputation. The English word for tort comes from the Latin word tortus, which can be translated as twisted. So somebody showing some twisted behavior, tortuous behavior. A person who commits a tort and has thus engaged in this twisted behavior is called a tortfeasor. The other party is alternately referred to as the injured party. The innocent party or the victim, if a lawsuit has been filed, the injured party is called the plaintiff, and the tortfeasor is called the defendant. Tort law versus criminal law. The primary purpose of tort law is to compensate the innocent party by making up for any loss suffered by that victim. So in other words, if somebody hits you, there could be assault and battery. So in other words, the assault is when they put you in fear. They put you in fear for your life. That's the assault. But when they actually hit you, that's the battery. So they put it together, assault and battery. But some states have them separate, and some states have them together. So assault and battery. So in other words, that's a crime as well. So that will kind of come on, assault and battery will come under criminal law, but you can also sue in civil court. So that's also a tort. In other words, you can also sue for money damages. Somebody hit you, and the thing is, money damages, if you are awarded money damages, that is to compensate the victim, or, compensate the injured party, and that is geared toward putting the injured party back in the state they was in before they were hit, before the assault and battery occurred. So that is what they call, that would be part of tort law. So then we have elements of duty. One approach to law is to think of legal liability in terms of elements. See, one approach to the law is to think of legal liability in terms of elements. So you have elements to a contract. You have 6 elements to a contract. So you also have elements to negligence. And other crimes too, you have a certain amount of elements to make it valid. So the existence of a legal duty. Duty is best understood in relation to rights. Legal duties arise because one of the objectives of the law is to promote justice. Justice demands that people be allowed to enjoy their health, their property, their reputations, their business relationships, and their privacy without the unjust interference of others. Since another object of the law is to promote harmony, a duty corresponding to each body also arises within each member of our society. So then we have intentional torts. Intentional violations of duty include a variety of intentional torts, all of which have their own individual elements. The principal intentional torts are assault. That's what I was saying. I was just talking about assault and battery. So the principal intentional torts are assault, battery, false imprisonment, defamation, invasion of privacy, misuse of legal procedure, infliction of emotional distress, nuisance, and interference with a contract. So in other words, you can't interfere with into a contract. In other words, you have 2 people that entered into a contract. You can't go and try to persuade one of those parties to that contract to get out of the contract, because that's illegal too. You can't go over there and try to persuade one party to try to breach their contract. And it says assault and battery. Under American tort law, assault and battery, though often closely associated with one another, are separate torts. It's assault and they are separate torts. An assault occurs when the victim is placed in fear, as I said, or apprehension of immediate bodily harm by a tortfeasor who has the present apparent ability to inflict that harm. No actual physical contact is needed for an assault. No actual physical contact is needed for an assault. The essence of the tort is the fear or apprehension that is created in the victim. Okay, here's an example of a case. They have James Dayton, a security guard for the Yellowstone Savings and Loan Association, was working in the lobby of the association one morning when Marsha Hayden, a customer, said something relatively harmless that annoyed him. Without warning, Dayton pulled out a nightstick, approached Hayden and waved the stick menacingly, like it probably was angry because she said something to him that he didn't like. Before he could touch her, he was restrained by another guard. Nevertheless, Dayton had already committed an assault. Right? He committed an assault because he put her in fear. So, right, so you don't actually have to touch that person. So, in other words, he waving his little wand around like that. She was so scared. So that's assault right there. When you put somebody in fear or apprehension, and then that is assault. So he didn't have to actually hit her, So it said before he could touch her, he was restrained by another guard. Nevertheless, Dayton had already committed an assault. So it says a battery involves an offense or harmful, unprivileged touching. So a battery involves an offensive or harmful, unprivileged touching. So you walking down the street and somebody just bump you in your shoulder, and they put that intent behind it. A lot of crimes are built on intent. So in other words, intent to harm. So in other words, you walking down the street and somebody just bumped you in your shoulder real hard, and they had that intent behind it. That's a crime. That's a battery. But if you walk down the street but you accidentally bump somebody and it's just an accident, and you say, "Oh, I'm sorry, excuse me," with no intent behind that. You didn't have no intent to harm them. You just accidentally bumped into them. But when you put that force and that intent behind it, intent to harm, then that's the battery. See, however, as the definition points out, a touching need not be harmful to be a battery. So it don't have to be harmful. But it can be harmful. You can have intent behind it and bam, boom, boom. And your intent, that's your intent. You intend to hurt them because you bumped them so hard, you bumped them so hard that you committed a battery. A physician who injects a patient with an antibiotic may be liable for battery, despite the physician's intent to help the patient, if the patient has not consented to the injection. In other words, you go to the doctor and I go to the doctor sometime. I know one time I went before and they want to know, you want to get a flu shot? I'd be like, no, I don't want no flu shot. So, in other words, if they would have just stuck me with the needle and said, hey, well, we're going to give you a flu shot anyway, just stuck me with the needle, that's battery. Because I didn't consent to no flu shot. I said no. So, in other words, they're saying, if the patient has not consented to the injection, it's also it also is interesting to note that a battery does not always require the touching of the actual person of the victim. So in other words, it doesn't have to be the actual person. It could be if you have your pocketbook or something, anything that's on your person is your body. You got a pocketbook or you have a cell phone in your hand, an ink pen or whatever, and somebody just knock it out, with that evil intent. Just knock it out your hand. So that would be battery too. See, a physician who injects a patient with an antibiotic may be liable for battery, despite the physician's intent to help the patient, if the patient has not consented to the injection. It also is interesting to note that a battery does not always require the touching of the actual person of the victim. So it doesn't require the touching of the actual person, I mean the actual body of the person. If the tortfeasor touches something closely associated with that victim, look, thus the bank security guard would have committed a battery even if the only thing he managed to do was to knock the purse out of the customer's hand. So if he knocked the purse out of her hand, like I said, you got a pocketbook on your shoulder or in your hand, or you got a cell phone in your hand, pen, whatever you have in your hand, and somebody come and just bam, knock it out your hand. That's battery right there. You just come knock something out somebody. Now if it's an accident, that's something different. You walking in, you walking somewhere, you accidentally bump into somebody, excuse me, I'm sorry, you didn't have no intent behind it. You didn't have any intent behind it. And then we have false imprisonment, when one party prevents another party from moving about freely. That's false imprisonment. The tort is called false arrest in some states. The victim of false imprisonment need not be locked in a prison or jail cell. In other words, you're walking down the street, you don't have to be in a jail cell. False imprisonment can be, in other words, somebody, you can't walk this way, you can't walk that way, they blocking you. That's false imprisonment too. This tort is called false arrest in some states. The victim of false imprisonment need not be locked in a prison or jail. So you don't have to be locked in a prison or jail. In other words, I'm walking down the street and they hold me back and I can't go this way, and they're stopping me from being free. See, the victim of false imprisonment need not be locked in a prison or jail. All that is required is that the person's freedom of movement be restricted in some fashion. For example, a patient who has been deprived of clothing for a physical examination has a cause of action for false imprisonment against a physician who refuses to return the patient's clothes until a partial payment is received for a long overdue bill. In other words, the physician or a nurse, prevent you from putting your clothes back on when you're at the doctor's office because you didn't pay your bill. That's false imprisonment. Store owners must be very careful about detaining suspected shoplifters because such a detention could result in a false imprisonment lawsuit. In other words, you go in a store and you're accused of stealing something, or even if you did, and then they, make you go to the back. They said stores have to be careful with that because they can get a lawsuit for false imprisonment. But it say still because of the growing problem of shoplifting in our society, most states have laws that allow storekeepers to detain suspected shoplifters if they have reasonable grounds to suspect that shoplifting incidents have occurred. So in other words, they do have laws in place just in case somebody come in the store, somebody going to a store or something, and then they do have laws in place that they can detain you, take you to the back of the store and say, hey, you know what, we have you on camera stealing, because they don't want to have no lawsuits. So, they have them cameras now everywhere. Then we have defamation. Any false statement communicated to others that harms a person's good name or reputation may constitute the tort of defamation. To be defamatory, the statement must hold the victim up to ridicule, contempt, or hatred. Defamation in a temporary form, such as speech, is slander. And then we have in a permanent form, such as writing, movies, video cassettes, or laser discs, is libel. And people can usually bring a libel suit, even if they have suffered no actual loss, whenever the permanent statement is damaging to their reputation. So if it's damaging to their reputation, they can still bring a libel suit, even if they didn't suffer no actual loss. So defamation of character, in other words, you go around telling somebody that person got HIV or something that's not true, so it has to be false. It has to be false, and you're going around telling, a lie on somebody, something that's false, defaming their character. Defamation of character, then you have libel, and you have slander and libel. So it says, individuals may speak the truth without being sued successfully for defamation as long as it is done without spite or ill will. See, the individuals may speak the truth without being sued successfully for defamation as long as it is done without spite or ill will. Then we have actual malice. That means that the statement was made or printed either with the knowledge that it was false or with a reckless disregard for its truth or falsity. Later decisions have expanded the actual malice test to cover public figures. Public figures are people such as television actors, sports figures, and rock stars who seek public fame and who are readily recognizable by the public at large. Actual malice, it means that the statement was made or printed either with the knowledge that it was false or with reckless disregard for its truth. In other words, somebody, printed something. They printed something and they knew it was false. They said they knew it was false. They said the statement was made or printed either with the knowledge that it was false. So they knew it was false, but they printed it up anyway. Just say, for instance, a newspaper like the Star or the New York Times or, whatever paper, there is out there, and they knew something was false, but they went and printed it anyway. So they did it with actual malice. They knew it was false, but they printed it anyway. So it said with the knowledge, they had the knowledge that it was false or with a reckless disregard for its truth or falsity. So they had a reckless disregard for the truth or falsity, but they printed it anyway, knowing that it was false. So then we have invasion of privacy, when one person unreasonably denies another person the right to be left alone. Invasion of privacy. The right to be left alone, which is commonly referred to as the right of privacy, includes the right to be free from unwanted publicity and undesired interference with private matters. So later on, one of my videos, I do want to go over the 27 amendments too. So all the 27 amendments to the Constitution, United States Constitution. So I really want to go over those too. So we have the, First Amendment, freedom of speech and religion, freedom of the press. So let's see, next we have, let's talk about the elements of negligence. So negligence, people in poverty are sometimes injured even when no one intends that the injury occurs. Such an occurrence is usually labeled an accident. Although no one acted with intent, someone was injured. Similar to a car accident, you get in a car accident, nobody usually acts with intent, but you had a car accident and somebody was injured. The victim has experienced pain and suffering, lost wages, and incurred medical or repair bills. Justice demands that the injured party be compensated. That part of tort law that is concerned with the compensation of accident victims is called negligent. So I said accident victims. Elements of negligence. The issue before the court in a negligence action is under what circumstances can the actions of an alleged tortfeasor be labeled negligent so that the tortfeasor will be held liable. 4 elements must be present to establish negligence: legal duty, breach of duty through a failure to meet the appropriate standard of care, proximate cause, and actual injury. So a legal duty, a determination that a legal duty exists between the parties must be made to establish liability through negligence. This is solely a question of whether the tortfeasor should have reasonably foreseen a risk of harm to the injured party. In other words, somebody drag racing down the street. They drag racing, on a public road, and they drag racing their car and they run into they run into the sidewalk, or they run into, actually they injured some people. So should they have foreseen that they would injure someone? So in other words, they drag racing on a regular, drag racing their cars with other cars on a regular busy road. So it should definitely be some foreseeability, because they have to have known that somebody could be injured. See, the issue before the court in a negligence action is under what circumstances can the actions of an alleged tortfeasor be labeled negligence, so that the tortfeasor would be held liable. So they have a legal duty. See, a determination that a legal duty exists between the parties must be made to establish liability through negligence. So in other words, if they're going to, if the case is going to be brought up against that person that's on that road, and they're on a road, and they know that that's a public road, that a whole lot of other people may be driving their cars or, walking on the sidewalks. So they have to have, those four elements have to be present for they can be charged with negligence. So in other words, legal duty, breach of duty, breach of duty, proximate cause, and actual harm. In other words, they have a legal duty. See, they have a legal duty. See, it says a determination that a legal duty exists between the parties must be made to establish liability through negligence. Then we had a breach of duty. The judge or the jury must determine whether the person accused of negligence has breached the duty owed to the victim. See, the judge or the jury must determine whether the person accused of negligence has breached the duty owed to the victim. So I'm like, you riding out there in that street, you drag racing down there in the road, and you should have foreseen that someone could get injured. So breach of duty, the judge or the jury must determine whether the person accused of negligence has breached the duty owed to the victim. A breach of duty occurs if the tortfeasor has not met the appropriate standard of care. So to me, that would not be the appropriate standard of care, because you shouldn't be out on that road drag racing your car and other cars, driving right by you, right beside you. This means that the alleged tortfeasor has failed to be careful enough under the circumstances. They failed to be careful enough. That person would be, to me, you have failed to be careful enough. So then we come to the proximate cause. It's not enough to show that the tortfeasor's actions were unreasonable. In order for the tortfeasor